the book that I read the Tate case from. This is the training book for certification of guardians, court evaluators. What's a court evaluator? Somebody hired by the court to make a recommendation to the court after an investigation into the AIP's functional levels and to recommend property management and personal management in the least restrictive way. That report does not have to be given to counsel. It often is, but it doesn't have to be. The court evaluator often has access to the medical records, whereas we might not, and it keeps the medical records out of the court files. Now, if you want to participate in this process as a court evaluator, as a court examiner, which is someone who reviews the financial data that is submitted by a guardian prior to the guardian or the attorney allowing to be paid, you must go through these training classes. Guardians must be commissioned. They must go through training classes. Theirs is a lot shorter. If you want to if your case demands that you get a bond, you'll notice in the case that you had in front of you, there was, what is it, a $600,000 bond? This was a very big case. You have to get a bond, you have to be commissioned, and you have to take the class. You can be appointed as a temporary guardian, but until you meet those requirements, you cannot be commissioned as a full guardian. The attorney for the AIP, I do not take court-appointed cases. Remember what I said? You can't get out of them if you get into them. And I have other parts of my practice. I just can't devote full time to this. So petitioners will come if I think they are credible and I'm interested in taking their case. I sign a retainer agreement with them, making the people who are bringing the petition responsible to pay me, because it is up to the court, as Chelsea said, whether or not you will get paid. The court, you have to be approved by the court to represent the petitioners. You have to file a notice of representation, and you have to file an affirmation of services at the end detailing everything that you've done. If you provide administrative services or things which the court deems not to necessarily be within the scope of legal practice, they can say, we're not going to pay you. If you get a retainer and a contract up front that the petitioners agree they're going to pay you for that stuff, you can still get paid. And oftentimes the attorney will find that you have to do a heck of a lot more than just, research a case and go to the hearing. The Rules of the Chief Judge, Part 36. This is meat and potatoes. You cannot believe this was not distributed to you, nor do you have to look at this stuff unless you're interested. You have a lot of materials that came out in the package to support this. There's information about medical representation and evidence and accessibility. There is an order to show cause. There is this petition. And there are 9 categories of people who have to be approved by the court to be paid by under Article 81, in an Article 81 proceeding. Guardian is allowed, and if you look at the order that was circulated, you will see specifically where the court has said appoint secondary appointments, where they have brought in, the court has said, I want you to bring in a geriatric care manager. I want you to bring in an attorney. Oh, here it is. I'd like you to bring in somebody. There was a property here that had to be sold. Bring in a real estate, a broker. Bring in an auctioneer. Those people are secondary appointments. The secondary appointments are subject to the Part 36 rules. And it can be anybody who helps. If you see on this list, these are the powers, plus anything else the court deems appropriate to grant the guardian. So, for example, if you need help in applying for government benefits for a Medicaid application, and notice, this was a very rich person here. The court wrote in a provision that if we prepare to apply for Medicaid benefits, surprised me. She died without needing them, but you know, you go through a lot of money when you're in 24 hours care 7 days a week for 10 years. Moving someone from one home to another, or from a nursing home, from their home to a nursing home, or creating a trust. These are things that a guardian may not necessarily be able to do on their own. The people that help them are the secondary appointees. I want to talk a little more about the Part 36 and why this is so important. There's a very sophisticated financial filing that has to be made after 90 days. Taxes need to be filed. And when someone dies, there's a final accounting. How you get paid is determined by Part 36 rules. Generally, it's under SCPA 2307 and 2309. Judge Kay in 1991 began an investigation, total reform of the system. There was an officer, and there still is, of the Inspector General of Fiduciary Appointments. Remember, the receiver, the court evaluator, the court examiner, the auctioneer, the attorney for the AIP, the attorney. You have the possibility of being sanctioned by the courts after an investigation by the Office of the Inspector General of Fiduciary Appointments, and every single county has an office now of a fiduciary clerk who is responsible to make sure that the right filings are done and the right payments are made. Fees for court appointees, this goes to your question a moment ago, are very, very low. You can only take a certain number of cases in a year. Each law firm can only earn a certain amount, unless you are appointed privately and then approved by the court, which is the kind of cases that I take. I'm subject to the Part 36 rules, but I'm not subject to a cap on my fees. How do they determine how you get paid? Well, standards. Time spent on a case, the difficulty, your experience, your standing in the community, the assets under management. Those are the 5 general standards. And there's a lot of case law on that.
Once a guardian is appointed, they do have responsibility because they're now fiduciary. They are acting, of course, acting in the best interest of the IP. But a few other more nitty-gritty things that they have to do. They have to get a commission within 15 days. That just shows that they've taken a training. So through the New York State court system, they have to complete a training and obtaining a bond if required by the court. Typically, we find that bonds are required when guardians are appointed to manage property and a lot of property. So if you're appointed to manage, $3 million worth of someone's estate, they're going to require a very high bond. You also have some filing requirements. Typically, you have an initial report within 90 days, and that just shows what you've done in the past 3 months. If you're of the person and property, both of those have to be included. And then every year, you must do an annual report on every account that the individual has that you are assisting with. A lot of times these reports get quite lengthy, and a lot of accountants assist with this report because it's a lot of numbers that typical guardians are not able to do for themselves. When a person dies who is under a guardianship, a final report is required to be submitted also, which is essentially a compilation of every annual report that has been filed. Besides these reporting duties, the guardian is also required to visit the IP at least 4 times a year, and that's at least. And also in this annual report that they file every year, this is information that's included when you visit the IP, where were they, how long, etc. The thing that's bolded here, which is probably the most important part, only act within the powers granted by the court. So the example, the order that you have there says the very specific powers that the guardian is granted. If the guardian is not granted power to do some estate planning, the guardian cannot do some estate planning for the IP. If the guardian is not authorized to hire a geriatric care manager to sell a piece of property, they can't just determine that it's in the best interest of the IP and go ahead and do that. If they do think it is in the best interest of the IP and would like to do it, you must petition the court for that extra approval. If it's not in the original order, you can't go ahead and do what you think. All this is subject to court approval.
Article 83, somebody mentioned before, and we'll pretty much close on this. This was brought about in 2015. Most states in the United States will recognize a uniform code of guardianship and allow reciprocal guardianships. I'll recognize yours, you recognize mine. This has streamlined tremendously the ability, particularly to sell property in New York belonging to someone who's incapacitated as deemed to be incapacitated by another state. One of the emerging issues is the lack of uniform procedures. Each county is figuring out how to implement this Article 83, and so I can't tell you that there's a uniform way of doing it. As a practitioner in this area, each of the judges has their own way of doing things. The forms that we gave you, the sample forms, are standardized now, but what happens when somebody dies and they're under a guardianship? How do you transfer from Supreme Court, which has jurisdiction over guardianships under Article 81, to surrogates court, who has jurisdiction over the estate?
Guardianship ends, right, on that?
The power of the guardian may end, but not the duties of the guardian. Somehow you have to get the assets into the estate. And what happens if you haven't been paid? And you still are appearing before Supreme Court because they have to approve your fees and close the guardianship, and you have a hostile executor in surrogates court. Well, let me tell you, this is what's called an area of vulnerability by the Law Commission, and I'm in the midst of one right now, and I'm not happy. So it's a sad situation. We really don't have a great way of dealing with this. If all the parties are cooperating, it's wonderful. If the parties are not cooperative and you are out, $90,000, $100,000, the commission of the guardian hasn't been paid, it's a real problem. A real problem. So protect yourself. Make sure that you take the classes you need to take. Make sure that you do the filings, and that you know what you're getting into when you service as a secondary appointee anyone who is under the protection of the court of an Article 81 or 17A guardianship. Okay. I think we managed, oh boy did we manage, right on the nick of time.